An Entertainment Law Guide. Chapter 1. Entertainment Law is Big Business. Entertainment Law Essay 1. The entertainment biz is not a pseudo-hippy-dippy thing where cool people hang out together united as artists of humanity making entertainment to share with the people because they're such good, cool, down-home folk. At every level, the entertainment biz is about money. Get a business book at number 650 to number 659 at the library to learn about business. I will state very broadly the major legal issues in the entertainment biz. Copyright law is a very important ownership issue that covers everything from minors to co-creators to an individual writing entertainment while in the employ of a corporation or manager. In every case, get a clear contract stating who owns whatever entertainment is created. Get it protected according to the copyright laws in your country. There are licensing rights where you allow others to sing, performing rights, broadcast, rights of broadcasters, retransmission rights, or record your song, recording rights, for a fee. When somebody writes a song that they don't intend to record themselves, they usually make a deal with the entertainment publisher to sell or license the song, which could be complicated or simple. The simplest contract is the outright sale. You sell the song for a flat fee and that's it. A more complex contract would be to license the song to multiple artists and get a royalty fee for every CD they sell with your song on it. Copyright infringement is generally a civil matter, although it can be construed as criminal for wanton fraud. The sides either settle out of court or go to court to hash it out. It could be the theft of the hook or entertainment of the song. For example, Huey Lewis and the News had a song out in the 1980s called I Want a New Drug. They were approached by the makers of the movie Ghostbusters to write a song for the movie, but they refused. Then several months later, when the song Ghostbusters came out, they said that the backbeat was a rip-off of I Want a New Drug and had a paper trail to prove that the Ghostbusters people were interested in it, so they settled out of court. Another case I saw was what I would call title theft and lyric theft. Some guy from the 1950s entertainment scene wrote some song, then 40 years later, one of the ex-New Kids on the Block kids wrote a song and recorded it, whereupon this guy sued him. The judge listened to both versions, which had some common lyrics, but concluded that the song was about a common simple love theme which was universal, so he threw the case out of court. If you steal someone else's entertainment, words or music, or think that someone has stolen your music, check up on entertainment copyright infringement law. The penalties are an injunction to cease performing or selling that entertainment piece, monetary damages equal to the defendant's profits plus punitive damages, and even jail time in some cases. As far as performing musicians go, if you get into a band, sign a contract upfront about what percentages of the profits you each get, even if you're just a garage band without a definite future. There are unions, agents, and managers. You pay a union fee, and in exchange, the entertainment union helps you get gigs, collect money, and resolve disputes. When you hire an agent or manager, even though he or she usually deals with the money, they are your employee. Sign a definite contract regarding money and promptly collect whatever money you're due, otherwise you will end up like Billy Joel, whose manager spent all his money. Make up a detailed personal management agreement. If you get big in the biz, hire a lawyer to watch your manager so that you will have two vultures watching each other. Watch that they don't get too cozy with each other, because it will mean they're working together to rip you, the entertainer, off. There are two types of live performance. Those performed within the union, American Federation of Musicians of the United States and Canada, which follow union rules. Non-union gigs, which have no rules other than the ones you make up. The union gigs have all kinds of rules guaranteeing all the players, musician, promoter, manager, a certain percentage of the take. There are copyright laws for recording your live performance and selling it. There are morality or decency laws for conduct while on stage. If you're a traveling musician, you will have to get immigration papers to perform in other countries. Everybody wants a record contract with a major company. That's the goal, but quite often with the record contract, you're signing your profits away. They have it rigged so you pay them back all their expenses before you start seeing profits, and if you hit it big, they have you with a several CD deal for low royalties. Essentially you sign your life away for your chance at a big break, which is to get manufactured and promoted by the suits. If you're really smart, you will go indie, promote yourself, record your own CDs, etc., which is not easy in a business dominated by a few corporate giants who control access to most of the commercial airtime out there. But if you go indie and get some public fan base on your own, you will have leverage when the big boys come calling to package you with a record contract. A record contract is not about two artists creating a song. It's big business. Have a legal mind on your side who will read the contract over and talk to you about it before you sign it. Then there's entertainment video bit, the ownership of the master recording bit, the distribution agreement, the CD cover, offshoot rights like putting the entertainment in a TV commercial, TV show, or in a movie, selling t-shirts and other band products. How far will you go to promote your product based on what the suits tell you to do? The deal is that the suits set up a publicity tour for you, but what if this includes demeaning appearances at shopping malls and appearances on kiddie TV shows? You must specify in your contract that you have the right to refuse to appear at venues you consider demeaning to your artistic image/vision. Because the entertainment industry is a business, many bands set themselves as a group partnership or a corporation in some cases and operate as this for business reasons, which is why you should read a business book and learn a bit about business. Finally, pay your taxes, because the tax people love to go after wealthy entertainers who they assume are more interested in entertainment and decadent lifestyles than taxes, and that's how they get like they got Willie. Entertainment has a vibe where you trust people and think all you have to do is play gigs and make records and everything will be alright. Your partners will steal your money, then the tax man will come calling with an outstretched hand. The entertainment industry requires specialized legal advice to navigate complex legal issues effectively. Here are some key areas. Intellectual property, protecting and managing intellectual property rights, including copyright, trademarks and patents. Contracts, drafting and reviewing contracts for various entertainment-related transactions, including talent agreements, production agreements, and distribution rights. Regulatory compliance, ensuring compliance with industry-specific regulations, such as tax credits, licensing, and broadcasting standards. Dispute resolution, advising on the resolution of disputes, including litigation and arbitration. Mergers and acquisitions, assisting with the legal aspects of mergers and acquisitions in the entertainment industry. Entertainment law Essay 2. Entertainment law is also called media law. Intellectual property law includes key components such as trademarks, copyright, and the right of publicity. The practice of entertainment law frequently extends into other legal areas, including employment law, contract law, torts, labor law, bankruptcy law, immigration, securities law, security interests, agency, right of privacy, defamation, advertising, criminal law, tax law, international law, especially private international law, and insurance law. Much of the work of an entertainment law practice is transaction-based, i.e., drafting contracts, negotiation and mediation. Entertainment law covers TV, film, music, publishing, advertising, internet and news media, etc. It also covers intellectual property, publicity, and privacy, and the First Amendment to the United States Constitution in the U.S. For film, entertainment attorneys work with the actor's agent to finalize the actor's contracts for upcoming projects. After an agent lines up work for an actor, the entertainment attorney negotiates with the agent and buyer of the actor's talent for compensation and profit participation. Some entertainment attorneys' job descriptions have become comparable to those of a star's agent, manager, or publicist. Most entertainment attorneys assist in building a client's career. Copyright law is the foundation of intellectual property protection in the entertainment industry. When someone creates a piece of work, whether it be a script, film, painting, photograph, or some sort of original piece, the creator of this work has exclusive rights to their work. This makes them a copyright owner of their piece. To make sure that your piece of work is under copyright protection, The U.S. Copyright Office at copyright.gov provides a public record of ownership, helping the creator establish rights in case of disputes. Trademark's role in entertainment law is to protect a person or company's ability to brand and market a product or service. A trademark can be anything from a word, phrase, symbol, design, of a combination of these things all together that lets consumers identify your company or brand. By being able to identify a brand's trademark, consumers are able to distinguish between brands and knowing which one may be higher quality. Companies are able to register their trademarks with the U.S. Patent and Trademark Office, USPTA.gov, which helps protect the company's identity or from others using their logo without permission. In entertainment law, the right of publicity is a right to legal action. This helps protect against the misappropriation of a person's name, likeness, and other things like a nickname, pseudonym, voice of signature, likeness, or photograph for commercial benefit. When it comes to the right of privacy, this is designed to guard an individual's personal rights against emotional distress versus the right of publicity being seen, protecting a property right. Entertainment law also covers social media, streaming platforms, video games, and other interactive entertainment sectors. At its core, entertainment law focuses on negotiating and drafting contracts, protecting intellectual property, and ensuring compliance with relevant laws and regulations. The digital revolution has spurred new developments, disrupting the previously established models for the creation, production, distribution, and consumption of entertainment. The law has had to evolve alongside technological innovation, creating digital rights management and online distribution agreements. Contract law governs agreements that establish the terms and conditions that govern the raw materials of entertainment, talent, content, money, and means of delivery. Labor and employment contracts spell out the terms of engagement for talent by studios, ensuring that both parties understand their obligations and compensation. Licensing agreements permit the use of content by third parties, while financing agreements facilitate the acquisition of essential funding. Distribution contracts determine how entertainment reaches its audiences. Intellectual property rights include copyrights, trademarks, and patents, which collectively protect the creations and brands at the heart of the entertainment industry. Patents concern new technological inventions and digital media formats. Legal professionals deal with everything from video game developer contracts to sports, athlete sponsorship, and social media influencer endorsement deals. In the film and television industry, legal professionals option literary works, secure project financing, and clear intellectual property rights for distribution. With entertainment increasingly transcending borders, legal professionals must navigate a complex web of international regulations to protect intellectual property and manage cross-border transactions effectively. One of the significant challenges lies in addressing cross-border legal issues, such as licensing and distribution rights that vary from country to country. For example, a film produced in the United States may involve distribution agreements spanning several continents, each with varying compliance requirements and market-specific stipulations. Piracy and unauthorized distribution are prevalent issues, necessitating international cooperation and robust enforcement strategies to safeguard creators' rights. Organizations like the World Intellectual Property Organization, WIPO, play a crucial role in standardizing international IP laws. The entertainment industry is witnessing transformations fueled by rapid technological advancements, including the rise of artificial intelligence, AI. AI-generated music and videos raise questions about authorship and copyright ownership. AI technologies challenge existing licensing and royalty collection models. Specialized areas of entertainment law. Entertainment law branches into various specialized areas that cater to distinct segments. Each area presents unique challenges and requires specialized legal knowledge and skills. Music industry. The music industry is a sector where entertainment law plays a pivotal role in protecting artists and studio rights that facilitate a thriving industry. Legal professionals negotiate recording contracts, manage music licensing agreements, and ensure royalty payments. They also address copyright infringement issues, an increasingly challenging task as digital distribution becomes more prevalent. Film, television, and streaming. In the film, television, and streaming domains, entertainment legal professionals are involved in every stage of production. They negotiate deals with actors, directors, and producers, ensure compliance with laws and regulations, and secure distribution rights. Legal professionals also handle complex distribution matters, especially as digital streaming reshapes content consumption habits. Interactive media industry. Video games, esports, and social media also present distinct legal challenges. Some entertainment law categories. Entertainment law is generally subdivided into the following areas related to the types of activities that have their own specific trade unions, production techniques, rules, customs, case law, and negotiation strategies. Film. Option agreements, chain of title issues, talent agreements, screenwriters, film directors, actors, composers, production designers, production and post-production and trade union issues, distribution issues, motion picture industry negotiations, distribution and general intellectual property issues especially relating to copyright and, to a lesser extent, trademarks. Internet. Censorship, copyright, freedom of information, information technology, privacy, and telecommunications issues. Multimedia. Software licensing issues, video game development and production, information technology law and general intellectual property issues. Music. Talent agreements, musicians, composers, producer agreements, and synchronization rights, music industry negotiation and general intellectual property issues, especially relating to copyright. Publishing and print media. Advertising, models, author agreements, and general intellectual property issues, especially relating to copyright. Television and radio. Broadcast licensing and regulatory issues, mechanical licenses and general intellectual property issues, especially relating to copyright. Theater. Rental agreements and co-production agreements and other performance-oriented legal issues. Visual arts and design. Fine arts, issues of consignment of artworks to art dealers, moral rights of sculptors regarding works in public places, and industrial design, issues related to the protection of graphic design elements in products. Defamation, libel and slander, personality rights and privacy rights issues also arise in entertainment law. Media law refers to the following: advertising, broadcasting, censorship, confidentiality, contempt, copyright, corporate law, defamation, entertainment, freedom of information, internet, information technology, privacy, telecommunications, entertainment case law examples. Copyright. In Golan v. Holder, the Supreme Court ruled, in a 6-2 vote, the judges dismissed contentions in light of the First Amendment and the Constitution's copyright provision, stating that the general population was not a class of sacred centrality and that copyright insurances may be extended regardless of whether they did not strive for new attempts to be made. Internet. In 2007, Viacom, a media aggregate that possesses MTV and Comedy Central TV, sued YouTube for $1 billion in light of copyright infringement claims for the unapproved posting of Viacom copyrighted material. In May 2008, YouTube began utilizing its advanced fingerprinting innovation to secure copyright-insured content. Television. In an 8-0 decision, the Supreme Court held that in light of the fact that the FCC rules at the time did not cover short-lived exclamations, the fines issued against Fox were unethical and subsequently discredited as illegally unclear. Music. Kesha v. Dr. Luke. In 2014, singer Kesha filed a civil suit against music producer Lucas Sebastian Gottwald, also referred to some as Dr. Luke, for gender-based hate crimes and emotional distress. This civil suit caused Gottwald to in return sue Kesha for defamation and breach of contract. This case ended with the judge declining to release Kesha from her binding contract that prohibited her from continuing her career effectively. The judge took note that Kesha had entered an agreement after she had sworn under oath that no harassment was taking place. Right of publicity. Helan Laboratories Incorporated v. Topps Chewing Gum Incorporated. In 1953, Helan Laboratories held an exclusive legal right to use the baseball players' photographs beyond simply avoiding liability, which Topps Chewing Gum violated by persuading the players to break their contracts with Helan. The U.S. Court of Appeals held that Helan Laboratories had the legal right, being right of publicity, to the exclusive use of the baseball players' photographs, and that Topps Chewing Gum infringed this right by causing breaches in Helan's contracts. Entertainment law websites: edwardslaw.ca, en.wikipedia.org/wiki/entertainment_law, entertainmentcareers.net, and sportslawjournal.com, hollywoodnetwork.com/law, indeed.com/career-advice/finding-a-job/what-does-entertainment-lawyer-do, juriseducation.com/blogs/careers-in-law-without-being-a-lawyer. keepmusiccoming.com, copyrights in music. kindalawful.com, lig.com/law/ent-law, lawinfo.com/resources/entertainment-sports-and-leisure, meplaw.ca, entertainment law, usb2.gov law360.com, variety.com, askalawyeroncall.com.